Hi, I'm Emma and I'm the head of the mental health team here at David Gray Solicitors. I'm here to talk to you today about what we can do to help you if you or a loved one are detained under the Mental Health Act. We have a large, dedicated, experienced team here at David Gray Solicitors with decades of experience. We have male reps and female reps, so if you have a preference of somebody you feel more comfortable with, we can certainly do our best to ensure that's possible. Ordinarily, if you are detained in hospital, we would come out and see you face to face, but if you feel more comfortable speaking to us over the telephone or some form of video conferencing, we can arrange that also. Depending on what section you're on, there may be time limits as to when you can appeal. So if you are detained under Section 2 of the Mental Health Act, our team will aim to come out and see you within 24 hours of being told that you're detained. And if you're detained under other sections, we aim to come out within 48 hours. It's therefore in your best interests to try and contact us as soon as possible so that we can make those arrangements to see you. If you're the person that is detained under the Mental Health Act, then when we do speak to you, we will explain to you exactly what it means to you to be detained on your particular section. Every section is different, and therefore we will need to give you specialist advice on your particular section. If you're not happy with being on your section, we'll talk you through your appeal rights. One of the main appeal rights that people choose to go for is for a tribunal hearing, which is essentially a court of law. We'll talk you through exactly what that tribunal procedure is, and we'll talk you through the various powers that the tribunal have, depending on the section that you're on. We'll talk to you about exactly what it means for you to be on the particular section that you are on. And we'll talk to you about your nearest relative. If you are detained under the Mental Health Act, you should have heard of your nearest relative. It's different to your next of kin, and it's not somebody that you can choose. It's dictated by the Mental Health Act. That person is usually a family member or somebody that you've been living with, and they have certain rights and responsibilities. Your nearest relative has the right to ask for your section to be discharged. Unfortunately, it's not that straightforward, and there is a procedure that they would have to follow. But we're happy to talk you through that procedure, or if you wish us to do so with your consent, we'll speak to your nearest relative and talk them through it as well. If you are the nearest relative and you're watching this and you would like some advice, then we're happy to speak to you also. Depending on the section, you might be eligible to appeal to the tribunal in your own right. If you wish to do that, then you would be entitled to non-means tested legal aid, which means that there wouldn't be any cost to you. We can talk you through the different sections and any rights you might have as the nearest relative. If you're the person detained under the Mental Health Act, you will be entitled to non-means tested legal aid for all tribunals, and if there are different types of hearings, you may be entitled to legal aid for those also. We'll happily talk you through all of those options. If you do wish to speak to us, then please do contact one of our team here at David Gray Solicitors. Thank you.